So Jennifer, I want to move now to question 3 and our final question, which really the advice that we're going to give is going to cover both children, family injunctions, which is that people are asking, how is my court hearing going to be conducted at this present time?
Well, Rita, in relation to how court hearings have been conducted since COVID, there has been a wealth of guidance issued by the judiciary, and it's quite difficult, I think, for lay clients to stay on top of it.
Absolutely.
I've provided a very helpful summary of the guide on my chamber's website, and people certainly can refer to that guide if they wish. But I think the overriding message, I would say, is that the default position now is that hearings are conducted remotely,
Yes.
Either by telephone or video. And there are now virtually no hearings which take place in the court building,
Okay.
where parties attend in person, where the judge attends in person. And that must be right, given the stay-at-home rules. Now, the flip side of that is that if a hearing cannot be done either by telephone or video, the approach has been to adjourn
Yes.
those hearings. And so that's why we've been seeing quite a few cases being adjourned, because the courts either cannot accommodate that many remote hearings in a day, or understandably, because there are some cases where remote hearings are simply not suitable.
Absolutely. If I can stop you there, and perhaps the first thing we could do is perhaps explore the different platforms, because not everybody is comfortable with various pieces of technology. And I think perhaps the first thing we could outline is who will be responsible for setting this up and the technology up for a respective hearing.
Rita, the responsibility for making sure that arrangements for a remote hearing are in place, really, the guidance provides very clearly for the responsibility to fall on the applicant,
Yeah.
namely the party who is bringing or making the application, if that applicant is represented.
Absolutely.
Now, if that applicant is not represented by lawyers, then the responsibility moves on to the other party, the respondent, if that respondent is represented. Now, if neither party, or if none of the parties, if it's a multi-party case, are represented by lawyers, then the responsibility falls on the court themselves
to represent. Absolutely. So
to make arrangements.
So my experiences as a solicitor have been quite varied over the last few weeks. So I've had adjournments. I've had some whereby the court have said we're going to make a decision on the papers. So I've submitted a position statement on behalf of my client, and along with a mini court bundle. I've had others whereby they've said they would just hand down a written judgment. I'm still waiting for them. And then I've had some that have been through a remote hearing. So we've had some telephone hearings, and then we've had some video conference ones. So perhaps we could explore the different video conferencing platforms for clients so they can be aware of them.
Well, Rita, we're using at the moment, when we have conferences, we use Zoom. I've used my chambers. We have various platforms available. And one other platform we use regularly is called LiveSize, which works very similarly to Zoom. My experience of remote hearings so far has been, when it comes to telephone hearings, I think that's fairly easy to set up. And normally the courts will have their own provider, which is BT, secure BT, making arrangements for that. When it comes to video hearings, my experience has been that the courts, and I'm talking about my own experience, has been that the courts have used Skype for Business. Which can also link in to users who already have LiveSize. So, for example, my chambers, our default position is to use LiveSize, but that would also enable us to connect to the judiciary court system, which tends to be Skype for Business. So there are quite a few combinations of platforms that you can use. And if you have a laptop or even an iPhone, it really shouldn't be a problem for parties to be able to join in.
Absolutely. And I did my FDR hearing last week was using Life Size, and very helpfully set up by your clerks. And I have to say it was a really good portal and very easy. So a lot of clients are going to quite understandably say, well, you know, Zoom's easier, I've got Zoom. And there's been a lot of press coverage about potential security breaches. Are judges in the courts erring away erring on the side of caution and stating that they don't want to use Zoom? Is that your experience?
I think they are. I mean, I have to say that for the past 4 or 5 weeks or so, having done the remote hearings I've done, not one of them has been on Zoom.
I agree. That's the same with me.
And I think that must be influenced by the fact that there are some understandably very concerning reports where Zoom has carried security risks.
Yeah. Absolutely. And obviously, just to point out to clients as well, is that there is the facility to record these hearings and provide them to the court. So there is that record, isn't there, for Life Size?
Yes, absolutely. But I think, just if I may add to that, that of course is not licensed for the parties themselves to make recordings of a hearing, and judges will give the warning before a hearing starts that the only recording to be made is really by the judge or the court themselves, because it's not permissible really for parties to make recordings, whether audio or visual, when a hearing takes place.
Absolutely. I mean, personally, my own preference is hearings to be conducted by video conferencing. I think it's much more personable. It allows people to see faces and reactions. And, you know, this is people's very important decisions about their lives, their children, their financial position. I think a telephone hearing personally can seem very aloof to me. Would you agree?
My experience of telephone hearings is that they are absolutely fine if we are dealing with 15-30-minute directions hearings. So very short hearings where no contentious decisions are going to be made. And I feel that they work fine for those sort of hearings. When it comes to longer hearings, FDRs, where it's important for people to be able to gauge facial expressions, body language, to have that more personal feel, I entirely agree with you. I think the way forward must be video hearings. And Rita, I wonder whether, just to give those watching a feel for practically how it happens, given your recent experience of FDR, of an FDR using Life Size, could you tell us maybe how that day was structured? Did you have the hearing on Life Size in front of the judge and then parties going away to negotiate?
The way that we did it, and it was arranged, may I add, by Pump Court Chambers. So one of the things I'd say to people, if you are represented and you've got a barrister, you know, not to be too worried about things. Most council's chambers will have all the facilities to set this up for you, and actually all the liaison between the court was done by your clerk, so that was removed from me, and the cost that would be associated to that to the client, and also the stress for the client. So the way in which we did it is that we had the hearing on Life Size. There can be breakout rooms, but we chose to do video calling on our phones at a different time, because obviously, understandably, people will be worried about the use of breakout rooms, pressing the wrong button, breach of confidentiality. And with this particular client and this particular counsel, we just found that it was easier to have our discussions through a separate video call and not through the breakout rooms. And then the respective counsel rang each other and emailed each other. So for example, when offers were coming through to each other, they were sent by email summarized so that we could all go on video call and read the email. I thought it worked really, really well. And I think in some ways, when it's very contentious, it removed a lot of that acrimony, just because we were all physically distant. And actually that did lead to settlement. It was much easier than I thought. Where I think it may, you know, it's not going to be right for everything. I think with evidence and cross-examination, I mean, what's your view on that? Ah,
Well, I haven't had the pleasure of having contested live evidence being given remotely, simply because a hearing of mine, which would have involved
yeah.
contested evidence over 2 days, was adjourned by the court.
Funnily enough, I
Um,
joked.
yes, adjourned by the court, despite, I think, both parties wanting to press on. Um, I think on balance, we could have coped with a remote hearing in that particular case, despite it being 2 days and live evidence being given. But ultimately, it's in the judge's discretion. In relation to what I personally feel um, uh, uh, as to whether remote hearings are suitable
Mm,
for cases where more contentious evidence is to be given, possibly going over 2 or 3 days. Um, I have to say that I'm minded to follow the recent views pronounced by the top judiciary, where if you are dealing with very, very difficult subjects, for example, children, particularly children matters, where live evidence has to be heard, where there might possibly be a language barrier
yes.
involving the clients,
Yeah.
or where there are, one or two experts having to be joined in and to be
Yeah.
cross-examined, I start feeling that perhaps the remote hearing platform, even if it's a video platform, does not, I think, provide the clients with the sense that they are properly heard,
No.
and that all matters are properly considered in a human way, because we are dealing here with very emotive issues. And when you are cross-examining a party, you need to be able also not just to see their facial expression, but the entire package. It's
No.
their body language. I don't see how you can really do that with a
I
video
agree.
conferencing.
And I think certainly for any clients who are particularly anxious or for any vulnerable parties, I don't think it's an appropriate platform to be asked questions by a barrister through some sort of video link. I would have concerns about that. So I think it brings us back to our point again that it's on a case-by-case basis. You know, parties may decide to adjourn hearings themselves or agree adjournments, or the court may take the view. And I'm sure if adequate representations were made by somebody's solicitor that this case should be adjourned, then I think judges would take that into consideration at the moment.
Mm. And Rita, if I could also hinge on the point you've made,
Mm.
um, this is where I think the lawyers can be very helpful in, I think, giving the parties the space and the information to make their own informed decisions, to be able to reach a resolution outside of court. For example, if a hearing is adjourned, there's no reason why the lawyers can't themselves, with the client counsel, have further negotiations, perhaps a roundtable meeting where we have, effectively the entire day to resolve matters, to discuss any issues, and to try to reach an agreement ourselves.
Absolutely. So what I think comes out of this, it has to be dealt with on a case-by-case basis. It really depends on the complexity of the matter. And I think the individual parties and how comfortable they are with dealing with things. But I think certainly straightforward matters or largely procedural hearings, I think, can quite easily be dealt with on a remote basis. And maybe the way forward as we move on. What's your view on that? Do you think we're all going to, after lockdown, snap back into having physical hearings, or do you think that this process has perhaps, brought forward these remote hearings that were always sort of in the background?
I think it will certainly encourage the courts and the parties to think differently about the use of technology when it comes to conducting hearings. I certainly don't see why this practice shouldn't catch on
Yeah.
once the pandemic is over, in relation to shorter hearings,
Yes.
so that both parties don't have to travel to court and judges can sit in the comfort of their own chambers without, necessarily having to move parties out and move parties back in again. I can see that catching on for shorter hearings. In relation to other hearings, though, I still very much think that we will move back in to the situation pre-COVID, where
Yes.
we have face-to-face, in-person hearings in court.
No, absolutely. And I think one of the other things I was going to highlight is that clients may be thinking, well, the judge won't have my papers. Well, in those circumstances, the solicitor, if represented, or the party who's the applicant, would be delivering via email or, Dropbox, etc., to the judge an e-bundle. So that would reassure people that the judge will have read the papers about their case. And that technology is there to do that.
Yes, absolutely. I entirely agree.
So the other thing that's been quite prominent in the news is about the fact that this lockdown is going to lead to lots of different relationships breaking down, and that there is going to be a divorce or separation epidemic at the end of this, and the fact that there are predicted to be quite severe delays in the court system. Now, my own view, and particularly speaking to you about how many cases you've had adjourned, and I've had cases on things that are put back, is that invariably those cases are going to build up and have to be dealt with. So I think delay is extremely foreseeable.
I couldn't agree more, Rita. I think the problem is going to be severe, to be honest, because given the scale of the number of cases which have had to be adjourned in the past 4 or 5 weeks, not just from my own experience, but from speaking to colleagues at the bar and speaking to solicitors, there are a great number of them. And I don't see how the courts can really cope with them, whilst also dealing with new cases, which are inevitably going to come to the court, given the current pandemic. So I'm afraid the delay is going to be a massive issue.
Yes.
If parties can try to resolve their differences with the guidance of solicitors and counsel, then I think that must be the preferred option.
Absolutely.
Otherwise, I think we are talking about many months before hearings are able to be accommodated.
And one of the things I'm saying to clients at the moment is that you have to envisage delay. Therefore, moving matters on is advisable. If you want to issue a Form A financial remedy application, you can do that so that it's there in the background. But alongside that, like you said, we can move things on, solicitor and counsel. But ultimately, they have that application in the background. But I think for people to think that lockdown will end and that's the best time to necessarily issue an application, and that won't be exposed to delay, is perhaps short-sighted. I think the delays are going to be for many, many months.
I agree, and we'll have to watch what happens. But I think delay will be inevitable, and in terms of the timing of whether or not people issue proceedings once the pandemic is over, I think it's got to be on a case-by-case basis. It's entirely it's a very personal decision, and parties might feel compelled to do so, because if there is going to be a delay anyway, well, why not issue the Form A as quickly as you can? So I think there are arguments on both sides. My instinct is that the number of people wanting to issue proceedings will be very high once the pandemic is over, because a lot of people, I expect, currently are sitting tight, not taking any action. They are desperate to move on, they can't. And so once the current situation is better, I expect those parties to immediately issue proceedings because they can.
No, I agree, and I think we never want LGFL to promote any sort of divorce day, but the reality is that these are anxious times, they're difficult times for everybody. You have families who may only spend the evenings and the weekend together with each other 24/7, working, children off school. Those cracks in relationship are going to be exposed to further pressures. So whilst I'm not saying there's going to be a divorce day, the reality is that a lot of relationships are not going to survive what is undoubtedly a very difficult time for lots of people. and that will lead to an increasing number of applications. So one of the other things that people may say is, well, you know, the judges surely can get through a lot more hearings remotely. And one of the things a judge said to us last week is that actually dealing with it on screen is incredibly tiring and wearing, and you can't necessarily get through 10 hearings, and you know, just because they're not physically here. So I think people should perhaps not envisage that remote hearings are going to mean the judge can get through seven in the morning necessarily. It's not the case, is it?
No, I think quite the reverse, because in our experience of having the traditional face-to-face in-person hearings is that you would turn up at court, your hearing would be listed at 10 o'clock, and there will be 2 other or 3 other cases listed at the same time. And because all parties are in the court building, the court can very easily ask a party in a case to come in, deal with that case. You might be sent out to further negotiate, and then the other case goes in. So a judge can, I think, juggle a lot more cases when the parties are all in the same building. Whereas with remote hearings, people have to make sure they connect or dial in at a certain time, and that remote hearing will have to end by a certain time as well, so that the judge can move on to a different case. So I think the reverse is very much true, Rita.
Yeah, absolutely. Well, Jennifer, I just want to thank you for your insights today. You know, testing times for us all and lots to learn. And I would say to everybody is to take independent legal advice as soon as possible and explore with your solicitor the alternative means there are available at the moment to resolve your matter. So thank you. That's Jennifer Lee from Pump Court Chambers and Rita Gupta from LGFL Ltd.